So, what happens to your property if you are going to separate or divorce? And you probably have some concerns. It's a big, scary thing. What is going to happen? What are the rules? What are the laws? Josh is back. Josh Wasylciw is back, and he is with Resolve Legal Group in Calgary. He has answers to many of these questions, and often it depends, right? It depends on your own personal situation. So be sure and always reach out and get that information from a lawyer or a legal professional that can guide you. But Josh is going to cover a lot of information here about, in general, how the law views your property. You can also listen to Josh on other episodes on the podcast. You can watch all of these podcasts on our YouTube channel and on our Life Changes channel on Public Place Network. All the links are in the show notes. We also have regular group meetings, online, virtual, free to attend every 2 weeks. There's some that are at noon, there's some that are in the evening. So you should be able to find a time to join us for that. Check our events page, divorcemagazinecanada.com/events. Link is in the show notes. And then you can have access to this information and actually ask questions of our professionals who are in these groups and get some information that can put your mind at rest, or at least you will feel like you're making an informed decision and know what the next steps are. There are also brand new magazines that came out March 1st. Those are available digitally online. They're quarterly magazines, Divorce Magazine Canada, DMC, and Life Changes magazine. So even if you're not dealing with a divorce, or you're through the divorce, but now you're dealing with other life changes, positive and negative, expected and unexpected, all of those changes can be really scary to deal with, even if they're positive, because there's so many unknowns, and we're here to support you in this community. I encourage you to like and subscribe to this podcast so that you always know when new episodes drop. Sign up for our newsletter too, because those are coming out 8 months of the year when there aren't new magazines. And there's a brand new one that was just out on April the 1st. And it's got even more resources for you, direct contacts. It's all hyperlinked and easy to access. So you have the current content. You'll know about any promotions or specials that any of our experts have. It's and upcoming events. It's just a great spot to find the information that you're looking for. So I welcome you to do that. Check out the links in the show notes. Now, let's get into the conversation with Josh and find out how property is viewed by the law and what some of your options might be. Welcome back, Josh.
Hi.
I think you are our frequent flyer lawyer, which is amazing because you have so much information that can help people solve some of the mysteries they have around divorce and separation. Just defining what some of this means or what they might be looking at, because I think the fear of the unknown is the biggest fear, worse than dealing with the information that is relevant in their particular case. So you're here today to give us an overview of what property division can look like. What are some considerations? Maybe some do's and don'ts. Yeah, welcome back. To remind us a bit about who you are for anybody who hasn't already listened to the past episodes, which I will link in the show notes. And then let's jump into this juicy topic.
All right. Sure. Happy to do that now that I've got everything kind of arranged the way I'd like it. And thinking about this a bit more, I would have done that beforehand. But yeah, so my name's Joshua Wasylciw. I'm a lawyer with Resolve Legal Group in Calgary. We are a law firm of 9 lawyers, and we've got 2 articling students right now, and a whole host of legal assistants and things like that. And we specialize in the area of family law. So that includes divorces, separations, child custody, adoptions, all that kind of stuff.
Fantastic. So you know what you're doing.
Well, I like to think, and my clients tend to think that I do, so I'll trust them.
Perfect. Now, property division is kind of an obscure title. Can you tell us what types of property that we would be talking about?
Absolutely. So when lawyers generally, I'm sure there's exceptions, but when lawyers generally talk about property, we mean anything of value, tangible or intangible. And what I mean by that is, the couch in the living room that you can touch, or some stock that exists in the cloud somewhere that there's no actual paper stock, but it's still an asset. It also, very broadly speaking, includes debts. So when we're talking about family property division, that includes all the assets and all the debts.
And that's something that can come as a rude surprise to people when they discover that uh, either there's debt more than they were aware of, or that this is something that they now need to consider as part of the divorce, that debt has to be dealt with. Who's going to take it on? And can you explain as well who is responsible for that debt and how that's determined?
Sure. Well, like every question every lawyer has ever been asked, the answer to it is it depends.
Mm-hmm.
And I say that kind of glibly, but also because it's true. Property division is sometimes clear cut and sometimes not. So, for your listeners who maybe haven't listened to the podcast in the background, what I'm going to do is give just a very brief background on disclosure. And essentially, what disclosure is it's at the start of any sort of separation or divorce proceedings. We need all the financial information from each side in order to determine a variety of things. That includes things like tax returns and bank statements and all that, but it also includes what's known as a Schedule A. And a Schedule A is a sworn list of all of your assets and all of your debts that you are aware of, either in your name, your spouse's name, in your guys' joint names, or if I own something jointly with my brother, I would have to disclose that too. And the idea is that both sides need to disclose absolutely everything, good and bad, so assets and debts. And the reason why I require my clients to do this is because this is one of the only ways of providing clients with protection when it comes to property. So if each side swears under oath that this is all the assets and debts that they have, and then they sign an agreement, generally speaking, that agreement is done. It is locked down. There is no changing that. One of the few exceptions where we can kind of wiggle our way through there and we can try to bring about change is if one side has deliberately hidden an asset. And I'm not talking about, oh, I forgot to include the pots and pans, but if somebody forgot to include, $300,000 in a bank account or something like that, and then 5 years later, it kind of comes out of the woodwork, we go back and we look at the Schedule A's and we say, oh, well, that wasn't on there, that this is an asset that hasn't been dealt with. We still need to deal with this. So it's really important to do the disclosure process first. Following that, very, very, very broadly speaking, the starting point is there is an assumption that anything that was acquired of value, so assets, any assets that were acquired during the course of the relationship are divisible 50-50. Now, there is no presumption when it comes to dividing up debts. The Family Property Act in Alberta, I did a quick search before logging on here for the word debt, and that word is not found anywhere in the act. So there is not a presumption that debts are going to be shared. However, I'm going to put like a giant asterisk beside that. And the reason why I'm saying that is because, practically speaking, almost all lawyers and almost all judges are going to share debt 50-50 as well, unless there's a really good reason not to. So even though that presumption is there, in practice, that's what happens more often than not. Now, property division is really interesting because despite this presumption being there that the assets are going to be divided 50-50, and despite this practice of sort of dividing debts on a 50-50 basis, the Family Property Act provides us with the presumption. And then in the next section, in Section 8, it says, Oh, yeah, by the way, the judges can do whatever they want. And here's a whole list of factors that they can consider when making a property determination. And they can also consider anything else that they think is fair and just to include.
Right. So it depends on
So
each case,
it,
definitely. And I think people understand that when they hear any of the experts that I bring. It's very relevant in general, but you do need to talk to a professional about your specific case. When businesses are involved, we now throw another layer of complication in there that, maybe that $300,000 they said only belonged to that business, and they've kind of channeled some funds that way.
So you're right, this can be problematic and at times very expensive. And the reason why I say very expensive is because if I back up two steps to just property in general, um, all across Canada, there's two different ways of approaching property. So one of them is to value it as of the date of separation. The other way to value it is the date of trial or the date of agreement. In Alberta, we take the date of trial or date of agreement position. The problem is, no matter which way you go, there are cases where there's been a separation and then 5, 10 years go by before it's actually been resolved. So we have this issue of how much is stuff worth? Bank accounts are easy to determine. Houses, they're a lot more easy because if nothing else, we have city assessments. They're not great, but there's something. But for something like a business, it is incredibly difficult to come up with an objective value on what a business is worth unless you have special training to do that. So oftentimes when there is a business involved, I will strongly suggest that the parties engage a business valuator who is generally speaking a CPA with expertise in looking at and valuing businesses. And they have all sorts of metrics that they use to evaluate it. And some businesses are quite simply just unique. I'm dealing with a file right now where there's a business that essentially there are no comparables because there just is nobody else doing this in Canada. So sometimes it can be difficult when you have a business to come up with that number. And ultimately, if the parties can't agree on a number, even with evaluators report, sometimes we have what's called the battle of the experts, and that's where we'll have multiple evaluator reports come in. At the end of the day, a judge is going to decide on what that business is worth, if nothing else.
You do hear of that evaluators can be very far from agreeing. And that does complicate things for you in your position and for a judge, because how do you, are you going to meet in the middle? Now, business debt, not just asset, business debt can potentially be something, if they are partnered in that business, have to be dealt with as well.
It does. So if we have a situation where there's two parties and one of them's keeping the business, that's relatively easy to deal with because we figure out what's the business worth, and that number is X. So let's say $200,000, and that's net of all the debt, and the accountants have kind of taken care of that. So on a spreadsheet, we will have party one's column, party two's column, and we'll list all the assets, under who's keeping what, and then we'll do the same for the debts, and we'll figure out, okay, what is party one's net worth? What's party two's net worth? And they're not going to be the same. So at the end, one of them is going to have to make what we call an equalization payment, which is a cash payment to move some over to the other side. So they're both left with exactly the same amount of assets on the chart. Now, sometimes, though, we run into situations where businesses, just like people, have more debt than assets, and the business might be looking at a bankruptcy. If that's the case, then what we really need to start to look at, and this is also true of other debts. So something that I see periodically is one party owes, $30,000 to the CRA personally, not through their business, but personally. In these types of situations, the big question is, was that debt used for the benefit of the family? So was the money spent that should have stayed in the corporation, or was the money spent that should have been paid to the CRA that either benefited the family, or if it didn't benefit the family, where did it go up? So what I mean by that is, let's say there is a debt, the business is in debt, underwater by $20,000. If we start looking through financial statements and we see, well, there was a whole bunch of money pulled out so the family could take the Disney World vacation and to go camping in the summertime and renovate the house and things like that. Well, both parties had the benefit of that debt. They had the benefit of that money. So they're going to shoulder that debt equally. And unfortunately, that tends to be the case even when one party might not know that the other debt exists until they separate. So sometimes we see that where there's hidden debt that comes out of the woodwork and it says, oh, well, I didn't know about this. But if one party's had the benefit of that, generally speaking, the approach is to divide it. Now, that's not always true. If we find out that there's a whole bunch of surprise debt we weren't aware of, and it turns out that the other side had a severe gambling problem or something like that, well, that's pretty hard to say that was for the benefit of the family. So we can make an argument that that type of debt shouldn't be shared.
That does clear up some of the questions that I'm sure people have around that, because business really does complicate a separation, especially if both people have been in it, or if money has kind of flowed towards family benefits that it was covered by assets in a company or a business. So yes, that can definitely be a surprise when it comes to separation, because suddenly it's like, oh, the money came from there and that benefited us, and it wasn't something, money we already had, because not always both partners are managing the finances and realize that debt is even being taken on to the extent it has been until they reach that point. And now they're on the hook for something that they thought had maybe been paid for and hadn't been a major expense. Now, something else that I have heard of recently, talking to some financial experts, when, say, a credit card debt is existing and one partner says, well, I'll take that on, that was my expenses, but both names are on the card, even a legal agreement, and maybe you can help confirm whether this is accurate, a legal agreement doesn't supersede what the credit card company is saying, because if that isn't paid, both names are on that card, for instance, both
So
parties are responsible.
So at the end of the day, the credit card agreement, without actually seeing it, of course, will almost certainly contain terms along the lines that all of the card holders are what we call jointly and severally liable for any debt taken on. And what that means is, let's say you and I have a credit card together because we're friends, and you put on there $1,000 worth of debt, and I put on there $200,000, or let's I put on there $10,000 worth of debt, say. But because, I decide I want to be a jerk and I refuse to pay that, the credit card company lands up suing us both. And if it goes through the entire process, we will both be liable for each other's debt. So if I declare bankruptcy and say, well, I'm gone, the chances are very good that based upon the credit card's agreement, they're still going to collect the full amount from you. So if you owed 1,000 and I owed 10,000, you'd be responsible for paying the full $11,000. Now, in family law situations, the agreements kind of ride underneath that. And this is one of the reasons why people pay lawyers to do these agreements. It's because we've thought of these things or seen these issues before. And generally speaking, what we want to see in agreements is a clause that says both parties will agree that as of X date or as of signing this agreement, they will close all debt accounts that are in joint names. If they can't do that for some reason, so let's say there's a mortgage on a house with a home equity line of credit, and the house has to sell and both names are on it, then what the agreement might say is, as of X date, each party will be solely responsible for the debt that they incur. And if one party lands up becoming liable for a debt incurred by the other party and the other party refuses to pay that, then the party who was wronged has the right to bring the matter to court. And if they're successful, then they can ask the court to have the other party pay their full legal fees for having to do that. Now, realistically speaking, that doesn't happen a lot. The court very rarely makes those types of cost orders, but there's the incentive in the agreement to do this. And if you are the party that has done this, if you're the one in the wrong, I almost guarantee you're going to be paying the other side something for forcing this to go to court. I just can't say how much. So there are ways in the agreement that we do try to look ahead and prevent these type of scenarios from happening. Something else that I'd like to touch on, though, before I forget, are exemptions. Exemptions are a huge part of where fighting comes in when it comes to the division of property. And what I mean by an exemption is, again, this is very generally speaking, but when you bring an asset into a relationship, you are presumptively entitled to keep 100% of that asset when you leave the relationship. So in a perfect world, if I had $10,000 in the bank account when I began living with someone, and that money stayed in there and I never touched a penny, and then 10 years later we separated, and that exact same amount of money that hadn't been touched was in that account, that's mine, 100%. Now, the problem comes in, that's not real world. People churn money. People pull money out of here to put it into there. Interest is paid and the account grows, things like that. So we have to also deal with, well, what about the increase in value over time? So if we take, let's say, a house as an example. If I bring a house into a relationship that is worth $300,000 and it's completely paid off, there's no mortgage on it, and then at the time of separation, just because of market conditions, that house has now increased to being worth $400,000, the partner will have a presumptive right to share in the increase in the value because that $100,000 increase occurred during the cohabitation period. Now, there are a lot of other ways that you can claim an exemption. Some of them include things like, so if you didn't bring something into the relationship, but let's say, you had a relative pass away and leave you a large inheritance, that is also presumptively an exemption. If you have some sort of a windfall, so something that you really didn't do to earn money, but you just got a whole bunch, then
Like an
presumptively,
insurance, say an insurance payout or something like that.
yeah, that's a good example. Insurance payments regard, especially if they relate to pain and suffering that you have incurred. So if you were in a car accident, I mean, that money is yours. It's to compensate you for the pain. Um, there's a couple of other large common ones, but there are these exemptions that come up and they have to be treated differently. Now, unfortunately, what we see a lot is people come into a relationship with something and then they commingle that asset. So I come into a relationship with my $300,000 house, and me and my partner decide that we want to buy a house together. So I sell that $300,000 house and I take all that money and I put it towards a down payment on a $700,000 house. And now we're living in this and it's in both our names, and then we separate later on. There's a lot of questions that pop up about, well, how much is who entitled to, and all these types of things. When there is the commingling of assets, the big question becomes, is the asset traceable? And there's two cases, Alberta cases called Harrower and Jackson, and they set out a really detailed analysis for how to trace these assets to see, can we still identify where they are and in what form? So if I give you an example that I give clients a lot of, the house came into the relationship were 300,000, but there was a mortgage on it. And then we lived in it for a while and both were paying down the mortgage. And then that house was sold and we bought another house. And then we took out a home equity line of credit to do some renovations. And then we went, on vacation, but then we were paying money back into it. At some point, we can no longer trace where that original money is because it has churned and been turned over so much that there may no longer be an exemption. The other thing that I want to mention about exemptions is when you take an asset and you place it into joint names, there is a presumption that you're gifting some of that asset to the other side. So if I have a house fully paid for when I come into a relationship and I put my partner's name on that house, the mere fact of doing that gives rise to a presumption that there's been a gift. So, what a lot of lawyers do is they say, well, we're going to presume that half of that was a gift. So, and then half of that will be shared. So the first half is yours, and then the second half we're going to split up. So you get 25%, I keep
Okay.
25%, and I keep 50%. The interesting thing is, though, there actually is no hard, fast rule about what percentage is gifted. There's nothing in the legislation that talks about we're presuming that this amount is going to be a gift. Lawyers come up with these things that tend to just feel right, right? They seem like they're fair, but there's nothing really to base this on other than, you know, what people have done in the past and what, of course, the courts have decided. But there's nothing to stop a party from arguing that gift should be 100% of the entire property or 1% of the entire property. So depending on how much a person wants to dispute this, it can be worthwhile or not.
On exemptions, if someone receives an example, like you say, an inheritance, let's say an insurance payout, some of these unexpected windfalls, if it happens during the cohab, they are still an exemption, correct?
Correct. Yes. So there is an exemption, but if commingling of those assets occurs,
Mhm.
you can lose that exemption.
Right.
So in a perfect world, what I would tell everybody is when you do have some sort of a windfall, open up a brand new bank account, put all that money in that one account, and then never touch it.
Mhm.
Again, I know this is not practical, but that would be the best way possible to protect your inheritance or your insurance payout or whatever your exemption is that you've received.
At the very least, you can track the exit of money from that account. More likely, you'll at least know where it went and how it was used.
You can. Generally speaking, though, the court will not perform a retroactive accounting analysis. So, what was spent by whom during the course of the relationship? Again, generally speaking, the court isn't going to get into that. There's this idea that by staying with that person, you have condoned, you have allowed the spending or the not spending to occur in the way that it has. Now, I say generally speaking, because when we do this disclosure exchange, we look backwards 6 months to start with. Looking at bank statements and things like that. And the reason we do this is because in those last 6 months, or maybe a little bit longer if we need to, if we start to see dramatically different behaviors where it looks like people are pulling out huge amounts of cash and, where's it going? Or if they're selling off assets to family members for $1 or something like that, then what we need to do is we need to look at, well, is this a dissipation of assets? Is this person doing this because they know that the relationship is ending and they're trying to protect whatever they can? If that's the case, we then need to claw those back on paper into the overall asset bucket that the family's assets are in and deal with them that way. So if a party has sold a car to their brother for $1, that's fine. But on that party's spreadsheet, their column, they're going to see car and it's going to be worth $45,000, whatever that amount is. So we can't force the brother to sell the car back, but we can say, well, you chose to sell it at an absolutely unrealistic price, it's a brand new car, I bought it a month ago, we are going to deem that to be an asset in your column.
Yeah. I mean, that's reasonable. But it's just some people, I think, are surprised when they discover some of what's been going on. And they wonder if, how do we know that you can find it all? And
Yeah.
what is the limitation on, like you mentioned, sometimes, say 5 years, something like this is discovered.
So at the end of the day, there is not a good answer here. There is nothing magic about it. The court can't make an order that, all banks everywhere divulge anything in John Smith's
Hmm.
name or whatever. Um, so a big part of why we do the Schedule A is because the person is swearing under oath that this is true and accurate. And by swearing under oath, if they knowingly lie or make a misleading statement, then that can be dealt with through the criminal code by a charge of perjury. That doesn't happen a ton, but theoretically it can. So
Yeah.
that's a big incentive to keep people honest. Sometimes I have clients come in and, gosh darn it, they know there's more. They know there's more. And I tell them, your finances better than I ever possibly could. You can certainly hire a forensic accountant to try to locate missing money, to look at the bank statements to see if it appears that cash is flowing to an account that hasn't been disclosed, to look at the past history. And generally speaking, a very, very, very basic forensic accounting will probably cost you about $15,000. And that is just scratching the surface. They're incredibly expensive to do. So unless a party is very sure that there is missing assets and there's a substantial amount of missing assets, it's really tough to say whether or not it's worth it to do that forensic accounting. Because if we're talking about a missing $5,000, you are guaranteed to spend more than that to find it. Um, the other thing is sometimes what I'll recommend people do instead of hiring a forensic accountant is to hire a certified divorce finance analyst. And these are people with training in looking through finances. They're not CPAs, but they have very particular training in looking at family law finances from a divorce perspective. And they can oftentimes find things that I can't because finance is not my background. So oftentimes we will refer people to somebody like this to come up with a proposal for the property division and to do the accounting work in the background to figure out who owes who what. And then we will take that as a starting point to then make our arguments as to what should occur. They're cheaper than lawyers and they are much better at this job than we are. So we often refer this work to them.
And that's amazing because that's part of what you have as a team of these other professionals in your referral system and in, that you can send people to for specific things like that. And that's a question that comes up quite often in our resource groups is, well, how do we handle debt? How do we handle property? I'm sure there's money somewhere else, and how can I track that down? I think that's a very valid point that you mentioned. It could cost you a lot more to look for, even if you're right, is it worth it? Like it could cost more than the value of what you're trying to seek. Maybe not always, but I do have a couple other questions. And I was just
Sure.
pulling up that email on my phone here that have come up recently in resource group. So one is, if I hold the house in my name only and most of the debt is in my name only, would my ex be able to get a portion of the assets but not have any responsibility about the debt?
So theoretically, yes, that is possible. Because again, we don't actually care whose name what is in. If it was acquired over the course of the relationship, it's considered a joint asset. There is zero protection by putting a house just in one partner's name and not the other. That being said, that type of scenario is incredibly unlikely because there would be no juridic reason why a court would do that based specifically and limited to the facts that you told me. It doesn't make logical sense to award somebody an asset, uh, but say, well, you don't have to take on any of the debt. Um, Judges really try to be fair about this kind of stuff. Now, again, if we look at my example from before and it turns out all that debt was, gambling debt because, the person liked to gamble, then maybe, I mean, theoretically, that certainly is possible, but it's unlikely.
Okay, that's good to know. Um, and that brought up another question that we do have come up fairly often, especially the women, and more so in my Hope in Hell group that is based around abuse. And some women stay because they are afraid that they will have no right to the house because only the spouse's name is on it, because that's still happening, is still in place in some relationships. And so, can you address that? Because my understanding is there's a thing called dower rights. You do have right to that asset. You're by leaving that home, you're not giving up a right to it. Once that relationship is dissolved, how does that work?
So it's a complicated question, and it's a very good question. So there are two components to this. There is, am I giving up a financial right to that home? Am I giving up my right to half of the value of it? And then the second component is, am I giving up my right to be there? So if somebody flees the home for a couple of days because family violence has occurred, and in those couple of days, there's an arrangement made where the other party is going to move out, they're going to move in. I mean, absolutely, they certainly have the right to do that. If they have left the home and 5 years have gone by and suddenly they want back in the home, well, the status quo for a long time at that point has been that the other person has been in the home, and there's probably a pretty big question there as to why the other party believes that they should suddenly be able to start residing there. Again, keeping in mind they haven't lost the right to half of the value of the home just to be there or not. You are right. The Dower Act does provide certain rights around this. It's not terribly pertinent for our discussion today. What is actually more pertinent is in the Family Property Act, Part 2 deals with the exclusive possession of the family home. So sometimes when there is a separation that's taken place, it becomes clear that the two parties cannot continue to live in the same place. Maybe that's because of domestic violence. Maybe it's because of just they're mean with their words to each other, and remaining there is intolerable despite there not actually being formal domestic violence. It's yelling and screaming, but it doesn't actually meet that threshold in the test to be that. So this section of the act gives the court the power to order one party to have exclusive possession of the home. And that would be then, so if the wife was given exclusive possession of the home, the husband has to move out. The husband has not lost any financial interest in the home. He just can't be there. So it would be like a friend situation. If the wife wanted to invite him over later, she certainly could. But if she said, well, you're being mean, I want you to leave, she has the right to ask him to leave. And if he won't, then you call the police and have that person removed. The court doesn't love making these orders because it is kicking somebody out of their house. So what the act does is it talks about factors to consider when looking at who's going to be given exclusive possession. And a big factor is what other accommodation options are available to both parties. So if one party has absolutely no other family and friends anywhere close by that city, but the other party has all their family and friends 2 blocks down, then that factor weighs in the person who has no other option staying in the house. If there's any court orders on file that relate to the house itself regarding property, that will be taken into account. If there's children in the house and there's been a parenting order made, then of course that's going to factor into it. And the court does this analysis to determine, oh, sorry, and there's one other one, and it is financial means. So if one party has all the income and they can afford to go out and actually rent a new place and the other party doesn't, again, that factor weighs in. So these things are all considered prior to making an exclusive possession order, and then the court will make an order.
That's interesting. That answers a lot of questions that we hear. I have another one about student loan. What if person A had a student loan prior to cohab? Person B paid that student loan during cohab. Would person B have a claim for that back after separation?
This is an interesting area. There's a few interesting areas in property that are difficult to apply the typical cookie cutter mold to. And so one that's come up recently that I've seen is tattoos. One party paid for all of the tattoos for another party, and they were now separating, and the party with the tattoos was walking away with tens of thousands of dollars in tattoo work. So to go to your question about student loans, this kind of gets back to the idea of what took place during the course of the relationship. Generally speaking, the court isn't going to undo. So if they took out student loans and over the next 15 years, somebody was paying back these loans, chances are that money is likely lost. I mean, that's kind of a unique issue that I personally have never encountered, so I'd have to do some work in that. But the general approach is we're not undoing 10 years of financial transactions to see who owes who what. Now, if somebody was in a relationship of, let's say, 1 year, and a month before the relationship ended, the other party paid off all their student loans with one big $25,000 payment, and then a month later they left, well, maybe that's going to come into play. This is one of those Section 8 factors where the court can say, well, I'm taking into consideration these other things in making my decision because I need to make sure this is fair. So something like that is very, very, very fact specific.
Yes, definitely. And another scenario that it possibly could happen is that person B used their line of credit to pay off that loan because maybe the interest is lower on the line of credit than what the student loan was, but that debt is still sitting there. So in that case, there is still a debt that they could address. Both people could maybe be expected at least share it because.
So this actually overlaps with something called the principle against double dipping. And what that means, broadly speaking, is if somebody's receiving something, so let's say somebody receives $100,000 out of the relationship, that $100,000 can be considered their income and then used for calculating child support and spousal support, or it can count towards their property division, but it's not going to count twice. The other side isn't going to be penalized twice for that. So in a case of the student loan, if the student loan has allowed that particular person to now have a very high income and they are now paying support to the person who paid off that loan by virtue of spousal support, then we need to look at the principle against double dipping here and say, well, how does this factor in? Because that loan is tied to the income indirectly, but there's also debt that's tied to the loan, and this person is paying support. So it creates an interesting legal problem that we would have to settle. And quite frankly, sitting here today, I don't know the answer to that. I need to think about it and do a lot of research before I could give a better answer.
Well, like most questions, Josh, I appreciate you attempting to explain this and at least explore it a little bit. But like you said, it depends. And we have very few details. That's all I had for details that were shared. And again, we just said we will check with some of our legal experts and try and sort out at least a general answer that, so I like what you say, where it's usually considered what happened is not going to be undone unless it was a really out of character type of situation that we're seeing.
Right. Yeah, that's generally the starting proposition. But um, because the division of family property is so fact specific and it changes from file to file, what works in one case might not work in the other. And what I'm thinking of here has to do with something called unjust enrichment. So, for example, if I'm in a relationship with somebody and I've brought my $300,000 house into the relationship, and it just sits there, right? It's paid for, and I'm living with my partner in a new home that we both own. And over the course of our 15-year relationship, my partner has been the one to be responsible for finding the tenants for my house, renting it out, doing up the contracts, collecting the rent, cutting the grass, doing the repair work, shoveling the snow, all this type of stuff. Well, I'm just sitting back here doing nothing. Well, maybe there's a claim for unjust enrichment because that person has enriched me through their actions. And there is no reason, there's no fair reason why I should get all the benefit of this, even though maybe on the face of it, they don't have a legal right to share in that asset. So yeah, there's a lot of different things that can factor into a property division claim.
Very interesting. Well, it's been enlightening to explore some of the scenarios that people might be facing, and hopefully they find some guidance towards um, expelling some of the miscommunicate or the misinformation that they've found from just asking their buddies at the gym or whatever it might be, right? Like there's a lot more to this than just you're going to lose everything or you're going to have to pay half of everything. And it's not that black and white, and it's best to seek counsel from experts such as yourself and really.
It is. You may save yourself some money by talking to your buddy at the gym in the short run, but it may cost you a lot in the long run.
Mm-hmm. Yeah, fair advice. What's one thing that you would suggest people consider as a starting point?
Um, well, on almost every file, unless there's some sort of emergency, the starting point is exchanging disclosure. It's important to get a good idea of what the other side has, and I would encourage your listeners to do that sooner rather than later. People who separate and then let 10 years go by and then decide that they're going to unwind everything, well, I mean, banks don't keep records that long. So first of all, finding out what was there can be difficult. Second of all, if you are unmarried, you don't have forever to do this. You have 2 years from the date of separation to commence your claim. Otherwise, you will be out of luck. Finally, it's just better, cheaper, and easier to deal with it sooner rather than later. So get the process started when you know it's coming, and just be upfront and transparent with the information, and you will save yourself a lot of time and a lot of money.
Good advice, Josh. We look forward to having you back and tackle some other topics in the future. And just, I think it's encouraging. The information is always, it's better than just the mystery or avoiding.
It is. Yes.
I hope you found that conversation insightful, encouraging, and also a reminder to all of us that what we see isn't always as it appears. People are going through a lot of things in their lives, and we would want that compassion shared to us, and that is something that we can offer to others without judgment. Instead, be curious and reach out, reach in, figure out a way that you can make someone's day a little better, and it might just start with a smile. I thank you very much for spending your time with me here today, and encourage you to please subscribe to the podcast, follow us on social media, check out our events. We have lots of ways that we can help you or someone that you love. Share this with a friend if there's someone that you know could benefit from this. And hey, keep smiling that beautiful smile, because the world really does need your sunshine.
It means a lot that you spend this time with us and meet our experts and professionals who can help you through whatever life changes you're facing. Please refer to our terms of service available on our website, lifechangesmag.com. The link is in the show notes. Our disclaimer: Divorce Magazine Canada, Life Changes Magazine and channel, and divorce resource groups are intended to educate and provide quality, credible resource information. The contents should not be used as factual until consultation with the appropriate professionals for any guidance. Divorce Magazine Canada, Life Changes Magazine, and Life Changes channel, as well as the divorce resource groups, do not constitute endorsements for, nor liability for any claims made in the presenting of this information.